obviously there's two factors here. One is that the defendant charged with homicide. He's killed 2 people, so he's clearly proven himself.
Allegedly.
This is obstruction. This is absolutely unethical. This is absolutely not professional.
What's your excuse for not turning it over to us? It's the charges that he's facing in the murder case. First-degree murder, 2 counts of first-degree murder. I don't know what the game is. I don't know what we're playing, but it's pretty disgusting, I submit.
YNW Melly had a bond hearing yesterday. The defense explains that Detective Moretti submitted more warrants 14 months ago and never notified the defense until a few days ago. Apparently, Detective Moretti and BSO are being extremely shady. The warrants are pertaining to stuff that's on appeal already. So it seems like the detective is trying to find a work around what's on appeal. It's kind of crazy. You'll see. Hit subscribe. Let's go, boys.
We don't know what documents she was relying upon. We don't know what materials she was given to review. We've been provided with no reports, nor do we know the substance of her testimony.
When was she listed as a witness?
She was listed, I believe, Friday evening.
So I believe they're arguing over the forensic psychologist that they submitted on the witness list in my last video.
Has information to provide to the court.
She interviewed your client?
Yes,
and she's going to testify about that?
Yes, Judge.
Okay, so the state's objection is sustained. She's not going to testify today.
Judge sustained it. She's not testifying today. I'm guessing because it was so late.
Judge, we can take a short break, and they could basically...
I already ruled this over.
Okay.
I'm not asking for your suggestion. Okay, go ahead and make all your witness.
That was the only witness that we had.
Okay, so is there any evidence, witnesses, or testimony, or is it just going to be your argument?
Then it would just be our argument.
The portions of the previous trial that subsequently Judge Murphy has found with evidence introduced in that trial that was obtained in violation of.
And
So
suppressed.
your position is that the exclusionary rule applies in a pretrial release or a bond.
I'm saying it should not be considered by the court because the court, the law of this case is it was suppressed and it cannot be used by the state in any way.
All the evidence that was suppressed by the previous judge can't be used by this current judge on whether or not he gives Melly bond.
Well,
It's
there's
not
a
record
authority
argument.
that says that it isn't.
No, I agree. And it's an unusual procedural posture that someone's ruled on a motion to suppress before they're ruled on a bond hearing.
I'm prepared to argue that, Judge, because
Judge Murphy's order that's dated December 21st, 2023, the last paragraph of this order says, the court has not been moved to consider the suppression of specific evidence. It is up to the parties to inform the court as to what specific evidence falls within the suppression order and what specific evidence is admissible pursuant to this order. So I'm going to take a wild guess that you all haven't gotten together yet and decided what is and what is not covered by this suppression order. Might I be correct about that?
no, not. Together, we have nothing.
This is what I want to know. I read the trial transcript, but I'm fully capable, no different than a Frank's hearing, of disregarding anything that I'm supposed to disregard. So what I need to know is what part am I supposed to disregard? Because Judge Murphy put in his order, you all were going to come up with that.
Yikes. And they never came up with any of this yet?
So what the court, or what the statute contemplates by that is if the state is some reason taking an appeal, which we did in this case, that his bond condition effectively remains the same. He's not entitled to the ROR. So I interpret that as because the issue is up on appeal, because the issue is essentially non-final, because it is before the 4th DCA now, that the exclusionary rule does not apply until there's an actual ruling from the 4th DCA, because obviously at that point there would be a definite change in posture depending upon what is ultimately suppressed or if anything is reversed by the 4th.
Would you look at that? State is using the appeal to keep Melly in jail.
I'll ask you the same thing. Judge Murphy's order said that you two were, all of you were supposed to get together and determine what specific evidence his order was going to exclude and what it wasn't going to exclude. So that never happened.
That never happened.
Okay.
In 10 minutes it's not going to happen, Judge. There was a lot of evidence that was recovered both from all the different
Hold on.
places.
Ms. Liberty?
There wasn't a lot of evidence.
No, ma'am. I didn't ask for it.
Oh, wait, did she say he was lying or something? I couldn't hear what she said. She said that's not true. There's not a lot of evidence.
I don't understand your continued behavior. Speaking out of turn, yelling at someone that that's not true. What part of the rules of criminal procedure or the Florida statutes or any case law says that you get to do that just when you feel like it?
My apologies, Judge.
Yikes. The judge is currently flaming Miss Liberty.
Did Judge Murphy allow that?
No.
I'm not going to allow that. But do you understand what I'm saying?
Judge.
Do you need any questions that I need to clear up for you on that regard?
No.
Everyone is entitled to respect. Everyone is entitled to be heard. One voice at a time for the court reporter. I'm not going to let anyone shout over you or interrupt you or call you a liar while you're sitting at the podium. And I can promise you, I'm not going to allow you to ever do it again.
Okay.
Do you have any questions about that?
No, Judge.
Okay.
If you're new to the channel, please hit subscribe. I appreciate the support. Back to the video, boys.
I have a general idea of what's going to be excluded based upon the date ranges that are provided in the order, but I'm not in a position to give specifics, and it would probably take more than 10 minutes to actually go through. And if we were to itemize everything, that's going to be a rather lengthy endeavor.
Articulates exactly dates and parameters of the evidence that was suppressed. I don't think it says Exhibit A, Exhibit B in that manner, but it does have the parameters of what was suppressed by date and description. So the other part that he wrote, I don't believe
He looks tired.
his suppression motion. It just, I believe,
That lineup the lineup needs some work. I can't imagine Broward County Jail barber is very good, so understandable.
that particular part says he shall be released in those other cases. It doesn't say, and he can't be considered in further bond motions. There's no law nor statute that says, or rule that says we can't come back and argue for his release after a year and a half of what's been going on.
I agree with you. That's why we're here today.
Right.
I gave you a whole day. I don't know that I agree with your interpretation. The court has not been moved to consider the suppression of specific evidence. So do you all want to tell me what you want me to not consider, or do you just want me to take a shot at it myself? I didn't have the benefit of sitting through this motion here. So I don't have an order that says a motion to suppress is granted regarding the defendant's statement. A motion to suppress is granted regarding the cell phone records from T-Mobile. A motion to suppress is granted regarding any of these things.
Wait, there was an order of motion to suppress partially granted for a bunch of things in detail that I read, like probably 6 to 9 months ago, maybe.
There's several that say he granted it in part and denied it in part.
Yeah, that's what I'm talking about.
May I clarify, Judge?
Sure.
In reference to his iCloud account, that they're limited to a span of 24 hours. Common sense dictates that he did not need to search his iCloud account for evidence and location and communications. So most of these were housed with that there had to be a specific time period. He set the time period from the date of the death, October 2nd, up into the date of arrest. So the YNW booking Gmail, that was suppressed for the purpose of the time period.
Yeah, it was just the time periods changed around.
Anything that predated the deaths could not come in, and anything after the arrest could not come in. We were
See what she just said, the state wants the opposite. They want everything that they got,
stuck to that time period. The next
not the time period.
one would have been Twitter. Twitter was based on the same analogy that the time period was too large and it had to be based upon date of death to time of arrest. When we go to the next motion to suppress, the Snapchat was out, time period predating the deaths, and then time period after arrest. Basically saying from October 26th to February 19th, all of Facebook can come up in, all of Snapchat, all his text messages can come in. So it was really clear that it was just, everything was out from before the deaths and after the arrest. So that's when you're looking at granted in part, denied in part. Is granted as to the probable cause of the warrant, but it's denied as to the span of the warrant. So even the new warrants that the state has applied for, because they applied for new warrants based on the evidence that was suppressed, they're going back to the creation of the account. Murphy was very clear that you can't go back to the creation of the account. You have to stick within this time period, and that's what was done.
Is that normal procedure for detectives to get a search warrant for an iPhone back to the creation of the iPhone account, which is probably 5 to 10 years? That's insane, right?
As to the first motion to suppress the T-Mobile records, that was denied. The cell phone location records where the defendant was that day with his phone moving around, that remains in evidence. As to the second warrant, the Twitter account, that was granted in part. The past events from leading up to the homicide were suppressed, which means the admission that was made on Twitter is kept in, but the aggravators relating to the defender's activity and belonging with gangs and his gang membership, that would be out. Number 3, the iCloud, that was granted in part. I think we noted that there was nothing of import there, so we weren't using anything from that, or we didn't recover anything from that. To the Snapchat, that was granted in part. Again, the day of the homicide, so the location information, the communication records from that day remain in. The messages from the defendant's ex-girlfriend, Mariah Hamilton, those occurred afterwards. Those would be out, but those were not introduced in the first trial. We do intend to use them, but those were not in the first trial. Number 5, the Google records, that was denied. As to 6, the Facebook account, that was granted in part. Physical location, FaceTime info, connection information, photos from the homicide up to when the warrant was suppressed on January, or when the warrant was applied for January 8th, that remains in. So what the state lost there potentially are photographs related to gang-related activity, the defendant's membership in gangs, as well as some comments and communications about the defendant promoting the promotional video, which is also subject to the appeal because we argued adoption by admission because he was promoting that video. But all those communications were after January 8th. The Instagram, which was number 7, it's effectively the same thing as the Facebook, the gang activity. Number 8, the T-Mobile records, the real-time location information, that was denied. Number 9, the T-Mobile records for historic location information into the defendant, that was denied. Number 10 is moot because it was the wrong phone. The detective got a new warrant. Number 11, the defendant's iPhone, it was granted in part from the date of the homicide up to February 13th. So we obviously kept anything that was backed up to that phone, including the pin drop information, some notes, some text messages in reference to gang activity, but what we also was suppressed were some of the notes and text messages from the past relating to gang activity. Number 12, the Google accounts. There were 2 accounts. We lost everything prior to the homicide was suppressed. That includes gang-related information as well as the gang Bible that was recovered from his account. And in number 13, which is what Ms. Collins was checking, the YNW booking. I actually didn't know offhand what was actually suppressed from that, but I believe it's more gang-related stuff. So effectively what was suppressed was a lot of the stuff the state would be using for aggravators.
Going to what specific witnesses testified to what we agreed was suppressed. You'd be looking at the majority of the testimony from Danny Polo would be out. He testified to a lot of the photographs of Mr. Denman's phones that predated. As Mr. Griffiths has said, the bookings, the YNW booking, Gmail had a gang Bible sent, some gang talk sent to that Gmail. All of that is out. That is most of what Danny Polo testified to.
Ah, interesting. A lot of the shit that was suppressed was a lot of what Danny Polo was going to talk about, because the larger time frame added in a bunch of the gang stuff to this case.
So the record is clear on this, but I'll put it in the written order also. I agree with the defense position. I'm not going to consider anything that was introduced as evidence in the prior trial that has been since subject to Judge Murphy's suppression motion.
So there you go. He's not going to consider a lot of the larger time frame gang shit.
What the state effectively lost, as I summarized, were a lot of the enhancers that were used, such as the gang activity, some of the information that goes to motive. But for the day of the homicide, the ballistics that shows that the shots were fired from inside the vehicle, the fact that Mr. Henry lied about the events, which was corroborated by the locations that were determined where the shooting actually took place, for the shell casings that were recovered, the fact that the defendant's phone was traveling with the 2 deceased in this case along with them and then separated prior to Mr. Henry going to the hospital.
So he's pointing out all the red flag evidence in this case where Melly's phones is being tracked around, all that.
Admission on Twitter that the defendant made where he said, "I did that."
Okay, I did that. Dude, I don't remember this case. It's 7 years old. I swear that was out of context. I gotta remember what the defense said about that.
To the homicide, to the direct evidence for the guilt portion remains in evidence. So effectively, nothing has really effectively changed other than some of the arguments that the state can present to the jury in terms of both aggravators and motive.
Based on their written pleadings, I suspect they're going to get up and tell me that since the jury didn't find him guilty of these, that's beyond a reasonable doubt. We weren't able to do that to the jury. So you're now asking me to find a higher standard, that is proof evidence presumption of great. So do you have any response to that?
My response would be is that it was a hung jury, and my understanding is that 11 of the jurors were ready to convict.
I have to object to that.
I have no idea what this is.
Then it was a hung jury, and we don't know.
He's pointing out that there was 11 jurors that wanted to convict him. Apparently it was one juror out of the 12 that was saying Melly was being framed. And she convinced, I think it was 2 or 3 other jurors to flip to her side, and then it was just hung jury.
It was mistried because they couldn't unanimously decide, which is the standard by which somebody is found guilty or innocent. So
No, I'm not considering votes. It was a mistrial. I got it. Anything else?
No.
Okay.
the 4th denied their seeking relief on that issue. So I believe that Ms. Boutros, who witnessed Mr. Moretti, the lead case agent in this case, suborn perjury, will come in with no cross-examination in the trial. And I believe the evidence of Detective Moretti suborning perjury in this case is another factor Your Honor should consider, because that didn't exist in the other trial. And it has occurred after the fact, and it's been ruled on by Judge Murphy that Ms. Boutros is going to testify unchallenged by the state in the next trial. And I think that's something Your Honor could consider. There's transcripts of her testimony and what she saw and what Moretti did, and I think that's another factor Your Honor should consider.
So now he's pointing out that Moretti, the lead detective, committed perjury. Michelle Boutros will corroborate that, who was a part of the state attorney's office member. She testified. Remember how messy that was? Literally, a person from the state attorney's office was testifying against the lead detective.
April 30th, so it's 5-6 days ago, a new set of warrants and affidavits authored by Moretti that were done a year and a half ago after Judge Murphy suppressed by this order for the same records that were stayed on appeal. And in those affidavits that he presented to various judges, nowhere did Moretti ever state that these issues were on appeal, that it was a stay, that they're asking for an expanded amount of records for the same social media and the same phones to a certain extent. And we found out about it a year and a half later, just the other day.
What is Moretti doing? Moretti submitted new warrants for shit that's on appeal.
Your Honor keeps reminding us we have this trial date, and all of a sudden, we get all of this other results of a search warrant that was signed by a judge who didn't even know about the appeal or what was going on with it. So all of that is additional, and we're going to do a motion on prosecutorial bad faith, prosecutorial misconduct, police misconduct. We have to add all this stuff to it because it's new stuff that we just learned about less than a couple days ago.
This trial can't get any worse. What are they doing? This just happened.
What are we doing here when the 3.220 says they have an ongoing obligation for discovery? They sought this information a year and a half ago in March of 2024, however that adds up. And they've had it since, and we don't get it until 5 days ago. This is obstruction. This is absolutely unethical. This is absolutely not professional. And this is the kind of thing that we're facing from this state attorney's office on an everyday basis.
Why'd they sit on it for 14 months?
And I believe that the sub-issues there of forum shopping to go to other judges who don't have the institutional memory of this case is about, and Judge Murphy was still there back when they sought these warrants. So did they advise Judge Murphy that we're going to go do an end around? Did they advise the fourth that they're going to do an end around and seek the same and expanded amounts of information from those cell phones when the judge said it was overbroad, and he suppressed all of the overbroad nature of those results of the search warrant? So it's under suppression, and they're telling another judge, go in there to try to get the same information, but broadly, so they can try to fix a warrant by not telling anybody they're doing it.
Jesus, man.
Coupled with the fact that certain evidence was suppressed. What Mr. Benjamin was referring to was on April 30th from 3:30 to 7 o'clock at night, a little after 7 o'clock at night, we received 5 search warrants that are in my hand. They were all prepared, I believe, by Detective Moretti. They were all signed by Judge Bober. They were all signed, I believe, over a year ago that we've never received until April 30th. Nowhere in these warrants does it make reference to the fact that Judge Murphy had suppressed portions of the items that they are now seeking. Nowhere in these warrants does it indicate that there was evidence that the affiant was suborning perjury. Nowhere in the fact does it explain why the state went to a different judge, because Judge Murphy was still sitting at the time, decided to go to a completely different judge, not disclosing any of these facts, because I question whether or not, had Judge Bober or any judge known this, they would have taken these 5 warrants and said, go back to the original judge. And I think that is something that the court should and must ask. And it's interesting to note that on these warrants, there is in the bottom left-hand corner, despite the fact that the warrants were signed in 24, an indication that says on one particular warrant, REV-AB 1124, which I suggest must mean revised by Assistant State Attorney with the initials AB on 1124, yet they give it to us over a year and a half ago. And may I tender what I'm referring to?
Well, I didn't limit anyone in any way. I asked you 3 times, do you have any evidence you wanted to present? And you all said no, and now you're making arguments based on things that are not in evidence, and I have no idea what it is. So.
Fair enough. Do you have any objection to moving what you gave us, April 30th?
Sir, you don't have to ask him.
Oh.
This is an evidentiary hearing. Yes, me.
May I introduce these 5 warrants?
Are they marked? Let's mark them as a composite exhibit. How about
Yes.
that?
The reason Mr. Benjamin and I make reference to that is because this is a continuing thing that's going on with the state.
I mean, think about this. This first trial happened almost 2 years ago. Why is the lead detective getting more search warrants for stuff that's on appeal?
Every other day we get something new concerning this case that appears was in their possession for at least a year, if not longer. I want you to know that if you look at the docket sheet, it took us 4 hours to organize the warrants because they were commingled. Warrant number 1 had pages from warrant number 2 or 3. And it literally took Mr. Benjamin's judicial assistant 4 hours to commingle all those pages, because originally they came in so convoluted. Because I printed out how they came in as another game that the state is presenting on a case where our client is looking at the death penalty. This is no game. And they have a continuing obligation under Rule 3.220. Not to wait a year, not to wait a year and 4 months, but they have an obligation to turn it over in a reasonable period of time. And if the warrants were signed by Judge Bober on 3/24, I think it was, of 24, what's your excuse for not turning it over to us? It's the charges that he's facing in the murder case. First-degree murder, 2 counts of first-degree murder, and accessory after the fact for the co-defendant. I don't know what the game is. I don't know what we're playing, but it's pretty disgusting, I submit.
Yikes. I mean, I'm just very curious on what Moretti is doing and why the state attorney's office waited so long to hand this over.
In the first trial, that wasn't suppressed, was a gentleman who took the stand, who said that Mr. Demmons got out of the car and went home and was no longer near the cell phone. That was in the first trial. That was something that the jury considered, which resulted in a hung jury. And that's something that I think is very important as we sit here today.
Pointing out one of his friends, Melly's friend, said he switched cars at one point. He wasn't in the car with the murdered victims. Now we got Raven Liberty's argument here.
Talking about the change of circumstances that we learned after the trial was over, after the hearing, the first hearing on the bond with Judge Murphy, we were finally advised about what had went on with Detective Mark Moretti and Christine Bradley. Why was that so important to us? Not only the fact that the jury was not made aware of that, and they probably would not have relied on his testimony, but his testimony actually impeached the testimony of Brendan Collins, the FBI agent. So when you read that testimony, you see Judge Murphy order that we redepose Brendan Collins for that simple reason. Brendan Collins had testified at that trial, which is in the CDRs, the T-Mobile, the cell phone data is in. State had put on Brendan Collins. He testified that you could not, with precision, give a location on that phone. Mark Moretti's testimony, period, we were deprived of knowing that he had previously perjured himself. We were deprived of the fact knowing that that lead prosecutor had asked him and basically covered that up. And there was a change of circumstances because that was not brought to anybody's attention when Judge Murphy had made his first ruling. And for the record, that first ruling that Judge Murphy had made, it wasn't an Arthur hearing, there was no testimony put on. I believe at the time the only testimony that was given to the court would have been over Zoom from the family's aunt or mother. What we would be proposing for Mr. Demmons would be a minimal monetary bond with the condition that the defendant would remain at his new residence. The defendant would not have possession of a firearm. The defendant would wear the standard pre-trial ankle monitor for GPS tracking. I did put on that witness list, I will not call him, was a member of the security company who...
Same type of bond package we hear a lot with all these guys. Ankle monitor, security guard.
Mr. Demmons would have a 24-hour security guard on his person. There would be then 2 other security guards on the property to basically secure the premises of the property of the house and the house. They would be reporting if there was any infractions of Mr. Demmons. They would be reporting directly to myself, the rest of the legal team, the state attorney, and to the court. You basically have your own deputy, paid deputy, with him. Mr. Demmons is not a flight risk. He does not possess a passport. I don't even believe he has a driver's license at this time. We can assure his presence at trial. He's been here every hearing. He will be here every hearing. He would have a monitor on him. The court would know where he would be at. There would not be any concern, actually, with him not being at court because you know where he's at all the time.
I think the main concern is the tampering of witnesses here. Considering he got charges for that, I think the judge will bring that up.
My proposal, with the security on, with the GPS tracking, basically house arrest, it would effectively prove conditions of release can protect the public from risk of physical harm. Given the singular event that Mr. Demmons is being accused of, it was not like, and I was looking at the different case law when we're talking about danger to the community. Those are the times dealing with a drug dealer and you're in fear of him coming out and still dealing to the community. That's not the issue here. Again, it was a singular event. If there was a concern for public safety, I think I would meet that concern when we would with our stipulation to the house arrest, the prohibition of firearms, and the ankle monitor. I think we could secure that there is no threat to the harm. I think the state's biggest argument today would be to assure the integrity of the courtroom, of the judiciary. And of course, they're going to bring up the witness tampering case. That case was very convenient. It was filed while we were pending our last motion for bond, and it does affect the integrity. You recently heard our motions. I was trying to lift the state to argue that C4 motion. The only person my client has been accused of tampering with was Mariah Hamilton. However, going specifically to that statute, it would require Mariah Hamilton was actually summoned to a legal proceeding. That legal proceeding is defined by that statute. The only thing that would be applicable was Mr. Demon's trial. The court said it many times. The record is devoid of any proof that Mariah Hamilton was ever under a legal obligation to come to trial. She wasn't. That is the only basis of what the state will argue, is that he's tampering with witnesses. There's been allegations he tampers with this person, he tampers with that person. But there's no proof of it.
There's no proof of it. Detective Danny Polo says it's on video of him sliding notes under her door. But can we trust Detective Danny Polo? Where's this video at? I want to see it.
Based off the true facts, there's not been any tampering. At 19, he could have ran, could have not did anything. He did the right thing, Judge, and he turned himself in. I believe February 13, 2019.
February 2019. Think about what you were doing then. Holy shit, that is so long ago.
Basic human needs, basically. He's currently housed in a situation that's 23-1.
Counsel, I hate to interrupt you, but there's no evidence of that.
Okay.
The lawyers don't give evidence, so if you want to present some evidence, I read that in your pleadings, but there's nothing in front of me about what his current conditions are in the jail, so I can't consider it.
Interesting. Judge said there's no evidence of his inhumane conditions in jail in front of him. No evidence like sitting in front of him. Well, how the f*** are you gonna get evidence of that? How, like, literally, how do you even get evidence of someone being treated terribly in jail without, like, fucking pictures and videos of it happening in jail?
The conditions in the jail aren't good. He's been there 6 years, Judge. The Constitution says everybody gets the presumption of innocence. 6 years. We're going now past 6 years. He has substantial ties to the community, to his mom, his grandma, his sister, his brother, his friends, his grandpa. They're all here supporting him. I don't have any evidence before you. We were precluded of putting my witness on. He has no risk of flight, though, Judge. I don't think there's anywhere in this world that Mr. Demons could go at this point without being known. There is no danger to the community. This was an insulated incident that he's being accused of. But again, I believe the special conditions that we put in place would protect the public from any risk of harm. They would also assure his presence at trial. And again, we would be protecting the integrity of the judiciary. And I believe we admit it, the state has not presented to us any reasons or any special conditions that would say that he should not be eligible for a bond. And I will also just point out that the whole purpose of bond is not to punish the defendant, is to assure their presence at trial. That's the whole basis, is to make sure they're coming to court, make sure they're showing up to trial, and they're not absconding. I believe there is enough before this court that the court can safely rely that he's not a flight risk, he will be in court, and the community will be protected.
I don't think this judge is doing this.
Yes, Judge, just responding to the points that were raised. Just so the court's aware, we have not litigated yet, but there is a pending motion to exclude the testimony of both Ms. Boutros and Ms. Bradley. It deals with a collateral matter, and we obviously believe that it's not going to be relevant to trial. They keep raising the issue, or they repeatedly raise the issue, that Detective Moretti suborn perjury, except there's been no finding of that, and there's no evidence of that, and actually the evidence tends to be to the contrary. Judge Murphy found no Brady violation in regards to Ms. Bradley. There were no findings of Detective Moretti's testimony during the motions to suppress. And attached to the motion to exclude her testimony is the IA clearance letter for Detective Moretti, finding that he had done nothing wrong. So when they say that he suborned perjury, there's no evidence supporting that other than their argument and the testimony of Ms. Boutros, which they say now is going to go unchallenged, except that's also not correct. While there is currently a court order saying she's not subject to cross by the state still has the ability to impeach witnesses. So she still is going to be subject to the same impeachment that she faced during the motion to suppress.
Oh, that objection. I'm sorry, Judge, that's just stating a fact is absolutely untrue.
It's not before me. I don't know why I keep.
I'm responding to their arguments.
Out your client's family members. I'm sure she's telling me the truth, but that's not before me either. I have no idea he's out there. I mean, I did 10,000 bond hearings in a regular division. Family members would testify. Here's our address. Here's our finances. Here's our ability to pay. You all don't do anything. So go ahead, Mr. Griffiths.
Just responding, that's all.
What is going on?
Obviously, there's two factors here. One is that the defendant's charged with homicide. He's killed 2 people, so he's clearly proven himself.
Allegedly.
He is.
Please, one at a time. Go ahead, sir.
He's already established that he presents a danger to the community, but not only that, he attempted to tamper with witnesses while in custody. It's actually the reason Mr. Henry is back in custody, because he did have a bond and that bond was revoked. Had Mr. Demons been on bond, his bonds obviously would have been revoked and he'd be back in custody as well, because there is probable cause that a new crime was committed. But to say that there's, and I'm not going to litigate the C4 motion, but to say there's no evidence is also not an accurate statement. There are videos, jail calls, kites all recovered that are part of the 23 case. So I don't think it's accurate to say that there's no evidence supporting the fact that he tampered or attempted to tamper with a witness. And finally, saying that there is nowhere that he can go, that he's not known, that's not the concern. The concern is if he goes somewhere where he cannot be returned. As the court has repeatedly pointed out, Mr. Demons is charged with the death penalty. Many countries in the world will not extradite back to the United States if they are facing the death penalty here. So the risk of flight with him is actually greater, because it is going to be much more difficult to recover him should he leave the jurisdiction.
I can just already tell this judge ain't doing this.
In light of my client's popularity, we opted not to put somebody on to give you the address of where he'd be living at. We were going to proffer, I would give that in camera as far as where he would live at. He would be residing with his sister and with his brother. I can give you the address. We would have the security detail. All of that can be given to you in camera. As far as the second amount, his record label would be, if there was a monetary bond in place, his record label is agreeing to put the monetary bond up for him. So the financials would be covered because it would be coming from his record label. He is actually duly employed. He has a recording contract. He would be able to work and have a source of income. And we'd have conditions in place to ensure. As far as what the state's arguing that they're afraid he would flee, I again think we alleviate any concerns when I put security on him. It would be essentially a private cop monitoring him 24 hours a day and another individual monitoring the property. They would be reporting back to not only the defense team, but to the state attorney and to the court if there is any issue. Again, the ankle monitor is being monitored. I have other clients on GPS, and I promise you, within minutes of them not being where they're supposed to be at, somebody is at their house checking on them. So to say that there is concern that Mr. Demons, while being on house arrest and a GPS tracking monitor, had abscond to another country is basically ludicrous, Judge. It's an impossibility. It cannot happen. We have met the factors coming under those three different combined statutes. It's protecting the community, protecting the integrity.
What's this man mumbling?
Of the judiciary, and basically making sure that he shows up to court. I believe we have proffered enough for the court to basically be able to rely on the fact that he meets those factors. The state has not raised any additional factors that would say, all right, he's not eligible for the bond.
Okay, listen, I appreciate the time, effort, and preparation on both sides. I'll get you a written order as to both cases, and the bond pending therein, or the motion pending therein. June 20th, 8:45?
Fine.
Yep.
I just realized June 20th is the day I fly across the country back to my hometown. Are you f***ing kidding me? That's the day of their next court appearance? What are the odds of that? All right, so it sounds like the judge is not ruling on this. Yeah, he's going to randomly rule on it in a written order. He's going to let Melly out, which I doubt he will. I've been saying this. This ain't happening, bro. This guy's accused of killing 2 people. That's a death penalty case. He's not letting him out on bond, bro. Comment down below what you guys think. Hit subscribe. Love you guys. Peace out.
Diamonds and diamonds.